Briahna, what's on your radar?
Well, Robbie, buckle up, free speech warriors. We have a live one, this time in the form of a decision from the 8th Circuit Court of Appeals. Yesterday, the court upheld an Arkansas law which forces anyone contracting with the state to pledge a loyalty oath. That's right. If you want to do business with the state of Arkansas, the state now has the right to force you to pledge in writing that you will not participate in a boycott of Israel. In effect, the ruling says that boycotts are not protected by the First Amendment. Here are the details. The Arkansas law went into effect in 2017. Under the law, if a contractor refused to sign a loyalty pledge, their fees would be reduced by 20%. In 2018, the ACLU filed suit to challenge the law. The law was tested when the state tried to compel the CEO of the Arkansas Times, a local paper, to sign the pledge. Now, for years, the Arkansas Times had run ads for a state school in the local paper. The CEO had no plans to join the boycott, divest, and sanction movement, but he refused to make his newspaper submit to the ideological edicts of the state. And so the state of Arkansas terminated its contract with the Arkansas Times. This is a clear-cut First Amendment case, and the court recognized it as such. The majority opinion explained that constitutional violations may arise from the deterrent or chilling effect of the government's efforts that fall short of a direct prohibition against the exercise of the First Amendment. As a result, the government cannot, through funding conditions, indirectly impair the freedom of speech, which, if directly attempted, would be unconstitutional. Now, that seems pretty straightforward. Seems like what's happening here. The state is coercing contractors to censor their own political expression via the BDS movement. But get this, the court decided that the BDS movement, which to be clear is designed to put economic pressure on Israel so that it will respect the human rights and territorial claims of Palestinians, is somehow not inherently expressive political speech. Because boycotting Israel is technically an economic maneuver and not one involving literal speech, the court held that it is not expressive conduct. Now, the court relied on a case, which I remember well as it was litigated while I was in school. The case involved several law schools who wanted to bar military recruiters from campus in protest of the military's Don't Ask, Don't Tell policy, which, as a refresher, excluded openly gay people from serving their country. In a truly dystopian move, the court then held that the federal government could make federal funding contingent on allowing military recruiters on campus because, again, the law school's refusal was apparently not inherently expressive conduct. Without literal speech, the court argued that no one would understand why a school refused to allow military recruiters on campus. So then preventing a school from enacting a ban on military recruiters was not considered to be limiting expression. Now, if that seems absurd to you, you are not alone. The court in the Don't Ask, Don't Tell case argued that what really mattered was whether a neutral observer would understand that what the school was trying to express by banning military recruiters. But everyone knew why schools were trying to bar military recruiters. Don't Ask, Don't Tell was a hugely polarizing cultural issue at the time. At my college, there was regular picketing and flyering in public spaces about our school's efforts to protest the ban on gays in the military. Here's a school newspaper story from my sophomore year. And my freshman year, 46 law professors sent a letter to then President Larry Summers urging Harvard to participate in the litigation. The reason was not opaque. The reason was gay rights. Just like BDS is not a movement in a vacuum. It's a movement for freedom, justice, and equality for Palestinian people. But apparently, the 8th Circuit is really not sending their best. The court found that if a company were to post anti-Israel signs, donate to causes that promote a boycott of Israel, or encourage others to boycott Israel, or even to publicly criticize the act, it would be protected by the First Amendment, and the Arkansas law could not stand. However, the purely commercial boycott, which to be clear, is done with the express purpose of securing a range of rights for Palestinians, is made magically non-expressive political speech because, I don't know, words. To make their not very sound point, the court and defendants repeatedly draw an analogy to a 1982 case called NAACP versus Claiborne Hardware. in which black citizens boycotted white merchants in Mississippi in order to pressure the white-owned businesses to commit to various demands for equality and racial justice. The stores sued to recover their losses and to block future boycotts. But the court sided with the NAACP, saying their boycott was protected speech. Now, truly, the only way the current court, the court in the Arkansas case, distinguishes the NAACP case from the Arkansas case is by pointing to the fact that the black Mississippians, quote, sought equal respect and equal treatment to which they were constitutionally entitled, and did so verbally with signs and picketing, as well as boycotting. Whereas the BDS boycott is framed as purely economic, as though BDS is about randomly wanting to stick it to Israel and not very specific human rights goals, like equal respect and equal treatment. So here we are, yet another clear form of political expression vulnerable to being barred by the state. ACLU lawyer Brian House has pointed out that this country was founded on a boycott of British goods. Moreover, liberal Jewish groups who oppose BDS filed briefs in support of the plaintiffs, arguing that although they do not support BDS, the decision is, quote, extremely dangerous because it essentially says that boycott itself, the economic activity, is not protected free speech. Former ACLU attorney Glenn Greenwald called it, quote, absolutely horrible, saying you either believe in free speech or you don't. Now, in light of the conversation we had yesterday about the decision which bars the state of Maine from making educational funding for religious schools contingent on a secular curriculum, it will be interesting to see if the Supreme Court says you can't deny funding to a religious school, even though the First Amendment bars the establishment of religion, but you can deny funding to a newspaper for failing to adopt the viewpoint of the state. Robbie, these keep coming fast and furious, and it is mind-boggling to me that there is not more outrage about this.
Yeah, I mean, probably not going to surprise you. I agree completely with you. I don't know what we're going to fight about here. I take a very, very broad view, and really so does the Supreme Court, to be frank, about what counts as speech. So I'd have to imagine the Supreme Court would feel differently about this. It's clearly we'll see. We'll see, but it's clearly, to my mind, protected speech that you can't.
I mean, we saw what has happened in this Maine case, though, right? Yeah. And I know we had some disagreement about it, and we talked today with a constitutional law professor about what's going on there. But there do seem to be these inconsistencies where the way the Supreme Court has held over time in various areas of the law is now radically changing. And Professor Siegel argued it's because of the religious and political makeup of the court. And of course, we've had conservative courts in the past, but specifically,
I don't think it's because of the religious makeup of the court. The court is supermajority Catholic.
Yes.
I don't know that their Catholicism
affects whether or not they have a different approach to funding of religious institutions, most of which are Catholic in the United States of America, as compared to their desire to protect the right to boycott.
Yeah.
Especially in this context where BDS has been so politicized. I mean, it's obviously a political issue, but it has been characterized so frequently as an anti-Semitic movement, a hate movement, and a movement that says, I just don't like Israelis, when it obviously has nothing to do with that or what's going on with the Israeli people as much as any other sanctions are supposed to be about, I just hate some random dude in Russia. No, it's supposed to be about this, in the same way that the boycott movement in South Africa was about pressuring the country to respect the rights of Black South Africans. This is very much the same thing. And the rationale in the opinion that tries to disentangle boycotts as something that's purely commercial.
Yeah, that's obviously ridiculous.
It's ridiculous.
It's just indefensible.
You can do it. I mean, you can make the argument. They did make the argument. But when they were talking about the NAACP case, it's like, okay, there was a commercial component. They're obviously boycotting the business. They lost business. But they were basically like, well, they had signs, they had flyers, they were outside advocating for racial justice. So anybody who saw the boycott understands its political expression. Therefore, that is constitutionally protected.
I mean, the Supreme Court has held that plenty of, maybe not commercial, but financial kind of stuff is speech, right? Campaign contributions can't be limited because they're a component of speech. We're taking a very broad view of what counts as speech. Conservatives have said that the sort of forced to bake a cake kind of categories of speech, or forced wedding photographer, that's expressive, that's speech, that's the view.
Yes.
I share that view. So you can't compel people to do services in that respect if they violate some principle they have, because that's compelled speech. Seems pretty similar to this.
Yeah. So I'm looking forward to seeing what the commentary is going to be like about this over the coming weeks, and whether we do get, some people on the left, sometimes I agree with them and sometimes I don't, will say, look, there's a lot of conversation about free speech in this country, and a lot of hand-wringing that comes specifically from more conservative parts of this country about all of these threats to free speech. And the right has really owned this idea that they are the free speech warriors. But I gotta say, there is a notable amount of silence when you have these huge cases coming down, whether they're these constitutional cases or these circuit court cases like this one from the 8th Circuit, that have an enormous effect on the state's direct infringements of rights. Not some campus professor said something I didn't like, or maybe I got a bad grade, or I had to quit my job because everyone was angry at me at Georgetown. No, this is the state saying you have to pledge a loyalty oath in order to get a contract. And we all know that state contracting is one of the biggest sources of jobs. You might not like that, but it is one of the biggest sources of employers in the country. So hopefully this is one of those areas, like when we're talking about military intervention, where we can really have simpatico between the right and the left in calling out these kinds of injustices and having social pressure to make sure that these kinds of laws are no longer promulgated. Yeah, I think you just straightforwardly can't have a loyalty oath test as a part of public employment, and that's just obviously a free speech First Amendment violation, but we'll find out. But I agree with you. Well, it's nice. We agree on this one. There's nothing to argue about. I just completely agree with you. Sometimes we agree. Sometimes we agree. Let's take the win. Let's take the wins when we get them. We'll have more Rising for you after this.